Lordship, I beg to mention item 2 and 3, Lordship. And
the
beg your
advance
Lordship's permission to file additional affidavit. In this matter, what happened, Lordship? In item 2, written statement was wrongly annexed of his mother, Lordship. So I want to bring on record the correct written statement along with some other documents also. And item number 3, Lordship, 2018 matter, normally we enclose the written statement and impugn order only. So we want to bring on record the exhibits also by way of
No,
addition.
because the TCR is available. We do.
LCR is available, Lordship.
So
The
therefore, not required.
vernacular is,
And if you make a statement that it was wrongly annexed, we can always refer to the TCR. We take your statement and we can refer.
Lordship.
In fact, adjournment, your requirement of filing may be exempted.
We want to bring on record some other documents regarding land documents and all these, Lordship. The rest, item number 3 is father and item number 2 is son, Lordship.
Okay, item number 1, 2. Mrs. R. Chaudhary, learned counsel for the petitioner, submits that an incorrect written statement has been annexed to the writ petition. So she claimed, she prays for leave to file the correct written statement as well as other documents on which the petitioner intends to rely upon. Next, all the respondents are represented. Next, prayer is allowed. List. After 2 weeks, most of the petitioner is granted liberty to do the needful.
Item 3 also, we want to file an additional affidavit by bringing on record the exhibits. But
Item 3. Simply, the counsel for the petitioner submits that certain exhibited documents are omitted to be brought on record. Accordingly, on our prayer, the matter stands adjourned. Today, to enable her to file the affidavit, bring on record the left out documents, left out exhibited documents.
along with
Next
some
one.
land documents also,
Huh?
Your Lordship, along with some other documents, land documents also, Lordship.
Okay. And other documents upon which he intends to rely upon. List after 2 weeks.
Lord, obliged.
Wait, please, Lordship.
Yes.
Lordship, item number 4, may kindly adjourn for the day only. Lordship, the Mr.
No, without advance
counsel has
information, we are-
Tapada is in medical, admitted in the medical.
Without advance information, we are not adjourning. Let the matter be
Medical
called.
emergency only, Lordship.
Let the matter be called, then we'll see. There's a adjournment slip for item 16.
It's not,
this- Item 16. Both sides are represented on the prayer made by London Council for the petitioner. The matter is adjourned today. List after 2 weeks. No, we'll consider it only after the record, after we call for the matter.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 6, Lordship.
No mentions are allowed.
Yes.
Unless advance information is given on Tuesdays and Thursdays, we are not adjourning any matter.
Lordship, I beg to mention of the listing of a matter. It was not listed since 2020.
Let me give it to the courtmaster.
Daily list item 1 for admission.
Yes,
Last occasion, there was a direct,
money has been released,
that was not released.
not released.
Not released. I have no instruction. Paragraph 9. ঠিক জমা দিব।
Whether money is deposited or not,
Pardon me?
we have already sent one letter on the 38, 25. Civil government advocate sent a letter. So.
No, but if payment is not made, then we'll have to enforce that payment.
Well,
My instruction is that from home A department, they have taken some steps, that they have already directed the DGP to take some action. But the written instruction I have not received. Give me some time, my lord. I'll.
How much time? See the calendar, tell us a date.
Lord, can this be on next Thursday? 1 week.
Friday, business matters. Okay. We are giving it on 7th, but do the needful by then.
7th is.
Oh, sorry,
8th.
5th.
5th.
I'm touching it wrong. Month. Mr. K. Kalita, learned counsel for the petitioner, is present and submits that the compensation amount as directed by paragraph 9 of order dated 6/8/2025 has not been paid to the petitioner. Next paragraph, Mr. D. Nath, then senior government advocate, prays for some time to obtain instructions. Next paragraph. In the event the amount is not released by now, the competent authorities shall take immediate steps for release of the compensation in terms of order dated 6/8/2025. Next paragraph, we hope and trust that the state would report compliance by the next digital listing. Next paragraph, list on 5/9/2025. Just before that, you say the learned senior government advocate is permitted to send a downloaded copy of this order to the competent authorities to enable them to do the needful.
Supply list item 17 for admission.
Can I pray for picking up this matter after some time? I just pray for a little accommodation. I think a motion matter after that. I'll.
Yes, item 4.
Item 4.
Wrong.
Wait. Lordship, Youngest counsel has been in the hospital, admitted in the hospital due to medical emergency only. That's on the matter for the day only, Lordship. Yes, Lordship. Mr. A. Tapadar. M. Rahman. M. Rahman. M. Rahman.
Learned counsel appears on behalf of the learned counsel holding the brief, and it is submitted that Mr. A.S. Tapadar, our learned counsel for the petitioner, is hospitalized due to medical emergency. Next paragraph. All the respondents are represented. Next, accordingly, the matter stands adjourned today. This after 2 weeks. It's like 2017 matter. Give a date after 2 weeks. What will you get?
Obliged.
17 September.
Obliged.
Item 5.
Yeah, no. Is what we normally থাকে. I don't find. থাকে normally.
Item 6.
Enter.
Mr. Sharma,
Lordship.
in this case, as per the order sheet, please taken that the man is mentally unsound. But we don't find anything except for the cross-examination where he has admitted that he has come into India after 25/3/1971.
Hmm.
And there is an order directing the medical examination of the petitioner, 3110.
Lordship.
The seal cover is with you, I believe. Can we have a look at it?
Lordship.
As per the order, medical report.
Hmm.
It is seen that the court by order dated 9/3/5/3/19 observed that the report of the medical board noted above shall be kept. Oh, this was not received. This man was taken into custody
Lordship.
and we directed a medical report to be submitted. Look at this order, 3110. My evidence to say that I am his adopted son. ये कोई से भी नहीं. And this person was also taken into custody after the opinion. Do you have his status?
I shall take Lordship.
Hmm?
I shall take this status, present status, Lordship.
Itu aku tuh IT. SP, halapan PPT. Okay.
Right.
Kaya sige.
No.
Night Ugly visa.
2 weeks time maybe.
I born at Bangladesh. I crossed over to India. आपने पूरा क्या करना है ना?
Lord,
In both as per none appears for the petitioner on call. However, comma, all the respondents are represented. Next para. The attention of Mr. G. Sharma and his standing counsel for the FT matters has been drawn to the order dated 30/10
22.
2022 to obtain the to produce the petitioner, the petitioner, namely the Kanak Datta alias Kanchan Datta, before the Silchar Medical College and Hospital. So as to enable these authorities of the said hospital to constitute a medical board comprising of at least 3 doctors from the psychiatric department, and to inform the superintendent of police within bracket border bracket goes Hailakandi within bracket now. No, Hailakandi, yes, Hailakandi about the date and time of the medical board. Just to present the petitioner before the medical board for examination in terms of earlier order dated 5/3/2019. Next paragraph. We also take note of the fact that as per order dated 27/3/2017 passed in this writ petition, this court had recorded that pursuant to the opinion passed by the learned tribunal, the petitioner was taken into custody, and it was ordered that the petitioner shall not be deported out of India until further order. Next paragraph. In the event the medical examination of the petitioner has not been conducted, the same shall be done preferably within a period of 3 weeks from the date of the order. Next paragraph, the learned standing counsel for the FT matters shall transmit a copy of order dated 5/3/2019, 31/10/2022, and order passed today to the superintendent of police within bracket border bracket was Hailakandi, just to enable him to do the needful. The next paragraph, the said authority is also at liberty to produce the downloaded copy of the order before the superintendent, the superintendent of the Silchar Medical College and Hospital to do the needful. Next paragraph. The present status of the learned standing counsel for the FT matters can also inform the court as to whether the petitioner is still under detention. Or he has been released on bail in the meanwhile. Bail कैसे दे दिया? It order comply ना हो.
clarified that in the event the petitioner has been released on bail in the meanwhile, comma, the superintendent of police border, Hailakandi, shall still take the petitioner for his medical evaluation. List on, give a date after 3 weeks.
17/9.
Some more time, Lordship.
Hmm?
Some more time may be allowed.
How much? 3 weeks is good enough,
Three.
I think.
Lord.
Today we'll, you can have it, have the order.
Yes.
The date is fixed on 17th. Okay, make it 19th then,
Lord.
2 days time to communicate.
Lord.
Document तो नहीं document तो नहीं
Lordship, a copy of the order may be provided. Lord.
My lord, sorry for the interruption, my lord. The previous item was my time. recast that order. Huh? Where we have referred to that order. From that place where we have referred to the order, earlier orders of mental evaluation. Before that. Uh, as per order dated 5/3/2019, the court had accepted the statement made by the learned counsel for the petitioner that the petitioner, all along, was suffering from psychiatric problem. And therefore, in his cross-examination before the tribunal, he had incorrectly stated that he is that Sri Ketoki, Kethoki, Ranjan Datta, alias Kiran Datta, a resident of Hailakandi town, is his adopted father, and that he had migrated into India in the month of June/July of the year 1971 with his uncle after the Bangladesh war. Full stop. Accordingly, this court had directed the plea of had directed the petitioner to be subjected to examination by a duly constituted medical board. Full stop. Thereafter, by order dated 31/10/2022, it was reiterated that the psychiatric evaluation of the petitioner be done by a medical board of 3 psychiatrists of Silchar Medical College and Hospital to examine the petitioner. Next para. On a perusal of the materials available on record, it is noted that there is no statement in the writ petition alleging that the petitioner was suffering from any mental health care issues. First off, we also take note of the fact that as per statement made in the synopsis, the petitioner has been apprehended at the time of his cross-examination next para. No, not next para, continue. We also take note of the fact that the affidavit in support of the writ petition is filed by Srimati Papia Datta, wife of the petitioner. Full stop. She has not annexed any document to show that the petitioner was under any sort of medical treatment on account of any mental health care issues. Next, therefore, comma, in the absence of any materials to show that the petitioner is or has been in the past suffering from any mental illness, comma, both sides are directed to address the court on the issue of mental illness of the petitioner, comma, as was projected by the learned counsel for the petitioner, comma, which is reflected in the order dated 5/3/2019, which is not supported by any materials on record. Full stop. Resultantly, comma, though the court, comma, in deference to the earlier orders, has directed, is issuing a fresh direction for medical evaluation of the petitioner, comma, yet, comma, the acceptance of the medical report, comma, if any, shall be subject to further orders that may be passed upon hearing both sides on the issue of projected mental illness of the petitioner. Then that other orders will come. You take note of that.
Sure.
You address us on the mental health care issues. Why should we accept it? Why should we should not accept it?
Yeah.
Yes.
My lord, I'm sorry for the interruption, my lord. My item was previous item, my lord, item number 5, my lord.
We'll take it up.
lord, I have a, my lord, desperate situation, my lord. My father is not well, my lord. I have a call from Morigaon, my lord. I have to go to Morigaon. Because of that, my lord, I could not take preparation yesterday. I'm very sorry to submit before your lordship. I know that today is a hearing day. I did not submit the, my lord,
Okay.
hearing slip, my lord.
Okay.
Any day, my lord, after a week, my lord, lordship will finally done 1 week time, my lord.
Money কৰিব নালাগে না এতিয়া এই সময়ত দেউতাৰ নাম কৈছে বুলি। We should not find him taking up bill matters. Okay. Okay, both sides are represented. This is item number
5, my lord.
5.
My lord.
Next, Mr. Zaid Hamad, learned counsel for the petitioner, submits that he has been informed yesterday that his father is unwell and therefore he could not make any preparation to argue the matter. On the said ground, the matter stands adjourned today, list after 2 weeks.
I'm deeply obliged.
Item 7.
Yes, sir.
Yes.
May I please Rashid? My lord, the improved order, that is page 36. But before that, my lord, I want to show the documents which I have to prove my citizenship. First, lordship kindly see page 13. This is Asiruddin and Tuljan Bibi.
Just a moment. 13.
Yes, 1-3.
Yes, who is Asiruddin?
Asiruddin is my father.
Yes.
And Tuljan Bibi is my mother. And
Yes.
their names appear in the additional voter list of 1966.
Where is your written statement?
Yes. Page 4, kindly see. Page 4.
Page,
4.
no, your written statement. Your written statement.
Or written statement, yes. That is page 23. 22. 22. The abortive portion appears page 22, para 7 onwards.
Okay,
That the name of father of the opposite party was has been
no, that's okay.
recorded
We
in the
just wanted to
electoral.
see that whether you introduce your mother in the written statement, it is not. Your mother is not introduced in your written statement.
It is there, later on it is there. The father of the opposite party has been recorded in the electoral rolls 1966 and 1970 as regular voter of 42 Avaibury SC. Now, mother's name is not there, but the document has been executed and it is said that Sultan Nasa is my mother.
Yes,
Then Lordship would kindly see page 14, 1-4.
yes,
This is Asiruddin Fuljan Nesa. Both of their names appear in 70 voter list.
yes,
Now, Lordship may kindly see page 1-5. Here is also the name of Asiruddin and Fuljan Bibi in the voter list of 1985. 66, 70 and 85.
yes,
Then Lordship would see page 16. There's Idris Ali and Asiya Khatun. Asiya is myself. So I was married with Idris Ali. So my name appears with Idris Ali. And that statement we have given. I am coming to that aspect later on. It is a voter list of 1997. Asiya Khatun, wife of Idris Ali. Then page 17. This is also a voter list of 2014.
yes,
Here names of my husband and my own name appears along with my son's name, Hamid Ali. Hamid Ali is my son. His father's name is Idris Ali, who is my husband. Page 17.
yes,
Then Lordship would kindly see page 18. Page 18, here, the Joa Bundi. Asiya Khatun, on the basis of the order dated 29/9/2016, the land by Dag number 77 is hereby mutated in the name of Siddiq Ali, Nendus Ali, son of Asiruddin, Asiya Khatun, myself, Asiya Khatun, Sabirun Nasa, Momirun Nasa, Asina Khatun, daughter of Asiruddin, my father. Wife of Fuljan Bewa, wife of Asiruddin, Pata number 10, Khiraz land in place of Asiruddin. So, in the Jamabandi, which has been issued on 1/1/11, which has been issued on 6/10/16, it appears that the all family members' name have been recorded in place of Asiruddin, his sons, daughters, and wife also. So this is a linkage document.
Later.
Then Lordship,
Just 2 minutes. Just two. Yes. Perhaps, perhaps Mr. Mahmood, you will change your opinion after reading this. Huh? कहाँ बोल
this
रहे थे?
land document.
गलती हुई से। हाँ, Yes, Ms. Verma, you have to read it with Mr. Mahmood. He will help you reading it. It's 66. Page 66.
Mr. Mahmood,
My lord,
you can read this in the meantime, you can help her. You can read loudly, so she can follow you.
yes. কুলবানু বেৱা স্বামী আসরুদ্দিন গাঁও নাৰাৰ ভিটা থানা মেৰেচৰ মই যি কম সঁচা কম মই মোৰ ছোৱালী আছিয়া খাতুনৰ সাক্ষী দিব আহিছো মোৰ স্বামীয়ে প্ৰথমে কেতিয়া ভোট দিয়ে মই ক'ব নোৱাৰো মই প্ৰথমে কেতিয়া ভোট দিয়েছিলো মোৰ মনত নাই 1966 চনৰ ভোটাৰ লিষ্টত নাম থকা সলিমন বিবি কোন মই নাজানো মোৰ কোনো নহয় 1966 চনত নাম থকা কুদ্দুছ আলী মোৰ ল'ৰা আছিল তেওঁৰ মৃত্যু হৈছে মোৰ ল'ৰাৰ নাম সিদ্দিক আলী তেওঁ এই গছৰ বিপৰীত পক্ষত আছিল বিপৰীত পক্ষ আছে একাত্তৰৰ ডাঙৰ মোৰ সিদ্দিক আলী তেওঁ এই গছৰ বিপৰীত পক্ষৰ আছিল আছে একাত্তৰৰ ডাঙৰ মোৰ ছোৱালীয়ে বিয়াৰ আগতে ভোট দিয়া নাই মোৰ ছোৱালীৰ আছে খাতুনৰ স্বামীৰ নাম মই ক'ব নোৱাৰো
Now, if you come to page 13, which you are showing us, page 13, which you were showing it to us, now you'll find that Quddus Ali is projected to be the son, whose age is 26 years and the mother's age is 35 years.
that and I cannot table beyond the record.
No, we understand, but since the mother does not know the names who are in the voters list with the same in this annexure 1 page 13,
Yes.
then everything falls.
No, it is true, my lord. Why I could not say, but thing is this, my lord, this Soliman Bibi and Quddus Ali, this Asiya Khatun shall not derive the Indian citizenship from them. She will derive citizenship from her father and mother also. As per section 3 of the Foreigners Act, either father or mother, both things are there, both are there. So here, Asiruddin is my father, Kuljan Bibi is neither, there is no doubt. There is no iota of doubt.
But
Now, so
there's no
far,
document to show that.
Soliman Bibi
There's no document
and
to show that.
Quddus Ali, I don't know why. It appears that both of these persons are her daughter or son. Soliman Bibi should be daughter, Quddus Ali should be son. So why he could not say, that is on record.
written statement. Mother, written statement by written statement. Mother wrote the statement. We get it. Yeah. That's all. Your name. You can use of the detail. You can use of voter and your name. certificate.
Now, Lordship may kindly see page 20. That is page 20. That is PAN card. And that has been exhibited. In PAN card, her father's name is there. Asiruddin. Now, her mother's evidence, Lordship may kindly see page 24. Because already father is dead. I, Musammad Asiya Khatun, alias Asiya Khatun, wife of Idris Ali, aged about 50 years, by religion Muslim, by nationality Indian, by profession housewife, a resident of village Tukarsor, PS Meresor, district Bongaigaon, Assam, do hereby solemnly affirm and swear in the name of God, what I state herein below shall be the truth, whole truth, and nothing but the truth. I beg to say that I am the opposite party of the, sorry, it is proceedings statement. I am the opposite party of the above noted case. I am well acquainted with the facts and circumstances of the case. My lord. Yes. Yes. His name is listed, page 25. Page 25. I beg to say I am an Indian national. By birth, I residing at village Tukarsor, PS Meresor, district Bongaigaon. That I beg to say that father's and mother's name has been recorded. Our name is not there. Not there. Not there. What do you want? Yes. Yes.
Page 30, Lordship. Page 30. Full Bhanu, Lordship. It's full Bhanu now. Full Bhanu.
My lord, normally this people after the death of husband, Beva is written.
Last time to sure. First piece. Last piece. First. Full Bhanu, yes, Lord. And the RTI also is a full Bhanu Beva. The thumb impression identified is also a full Bhanu Beva license.
Verification word is not there, but the contents of verification may be seen page 29, can you see, page 29. That the contents of this affidavit are duly read over and explained to me in vernacular, and the same was drafted on the basis of my instruction, and on being understood the contents of the affidavit by me, and I signed this affidavit on this 12th day of February 2016 at Abhayapuri. So that is to some extent that is there. Regarding some anomalies in names, my lord, I have given a little explanation in para 8, page 8. Kindly see page 8, para 8.
Improvement because of the fact you have annexed the land document somewhere.
Yes.
Which page is that?
Land document. Page 8,
Page 18.
1-8.
Look at your English translation. On the basis of, please read that. On the basis of,
On the basis of the order dated 29/9/2016, the land by tag number 77 is hereby mutated in the name of Siddiq Ali, Nendus Ali, son of Asiruddin, Asiya Khatun, Aisha Khatun, Asiya Khatun, Sabirun Nasa, Movirun Nasa, Asina Khatun, son of Asiruddin, Fuljan Bewa, wife of Asiruddin, under Patta number 10, Kiraji land, in place of Asiruddin, son of Akbar Ali. So these are there.
yes. No, it is there, but we thank someone who has done the English translation. He deserves a thanks for us. We may omit to read page 19. In page 19, you will find this Fuljan is serial number 10, Fuljan Beva.
Yes.
So this person who has done the translation deserves a thanks. Our work is lessened. Now this is again Fuljan Deva, and therefore this the omission of translation may be to have our notice escaped from the fact that even in 2016 when the Namzari was made, the lady says her name to be Fuljan Deva,
Deva.
not Ful Bhanu.
Yeah. Fuljan Bewa it is here.
Then
Some explanation I have given in page 8. But I'll see page 8, para 8. I understand. something also, my lord, beyond our capacity, because what has come from there, we can improve that.
Two thousand sixteen is again a very controversial date of having this this mutation. The fact is that the IMDT reference is to 2004. When the father died is not stated anywhere.
But it is understood from the voter list.
No, that can't be understood. To understand that somebody has died, we need 7 years time under 108.
That is not written. That is not written. How can I cannot say at this stage. But linkage is there. no? Because
How? This shows how. That's what we are asking you. Shows how.
and the mother's name is there. Mother testified that she is my daughter, and no, it cannot be thrust by other party. The mother says, Asiya is my daughter. And that mother's name is recorded in voter list of 1966, 1970, and as well as I think 80 also, 85 also. So in that view, when a linkage is found, there are anomalies, so many defects in papers, but the statement, the record says that, and also the address, if we, when a person, for a moment I also pay attention, in 60 voter list, page 13, their address was Nararvita. In 70 also Nararvita, page 14. Then page 15, it is also Nararvita.
Incomplete.
Then after marriage, it is Tukkar. A second Tukkar. And page 17, with husband, there is also Tukkar. So in that view,
Her first voter list is when?
6 is page 13.
No, the proceedings first.
Proceedings first list, my lord. That is page 16,
The 16 is 1997.
97 years. This is village Tukkar. And next one is 2014 village Tukkar. Same address.
Did she say when she was married? The date of marriage?
That of marriage is not
The
written here.
year of marriage is also not there.
It's not there.
नाही द्या नाही कुठे नाही not accepted.
Now please come to this page number 28.
Yes. Some explanation is there,
In
madam.
page 28, paragraph 8,
Yes.
the year of marriage is purposefully omitted. I got married with so and so in the year. Left blank. You see, we have a reason to ask when she was married. As per her evidence, she was 50 years on 12/2/2016. Therefore, she would be born sometime in 1966. And her age to vote will start from 1987. That means 89. '95, this 97.
Her name appears lordship for the first time in 1997 at the age of 35 years.
That's what we're trying to ask. Where was her presence all throughout?
Obviously. Obviously, I'm actually. The second and the. Motion. and the-
Some other voter list may be also there, but 35 years have been provided. That does not, we should not be taken so seriously because addresses are same, father's, mother's name. Of course, mother's name, there is a little difference. So these are common in this society.
Perhaps your opinion will change when you are a lawyer on this side. Then you will not like a judge who says that I don't take things seriously.
Or affidavit to-
Very carelessly cases conducted, I understand. Because something
No, we
should
don't
have been
know.
elaborately stated, particularly that of birth if or at least or in around. So these things are, names
can-
are, that is also there. This other land documents are also there, but those were not exhibited. But on the basis of the exhibited documents, my lord, if your lordship think that actually there are some mistakes, that affidavit is not verified. So now the parties are not supposed to know all this. These are the things to be done by the lawyer. So if your lordship think because citizenship is a very valuable right, most valuable right. So case may be remanded back, my lord. In the interest of justice, my lord.
Okay, thank you. Yes, we can put it.
Okay, yes.
Lordship. I would like to start with the written statement first, Lordship. And for that, I'm relying on two judgments, Lordship. One
But
is,
Mr. Mahmood,
My lord.
you see, you can do a good service to your community by organizing, by sharing your experience with members of the bar who are really doing this foreigners cases. Your vast experience you can share with them, upgrade their lawyering skills, because we are trained to always address the members of bar as learned lawyers.
Yeah.
There's only one occasion I am told.
That is
There's in the history of this court, there's only one instance where one of the honorable judges, while dictating an order, suddenly remembered and told the stenographer with full secretary with full audience before the entire audience that okay, that learned, strike it out. It's only one instance in this court where this happened, that the honorable judge had to have the learned striked out from the order. But you should share your experience, have this counsel trained in various aspects
It
of
is
this.
most essential, most essential. But we tried from our personal side, but they did not cooperate.
No, they-
That is the problem.
we won't say anything.
Yes, Ms. Verma.
But my lord, my last prayer is this, there are anomalies, there are defects, there are wrong conducting of cases carelessly, but even then what documents have been annexed, those at least give a impression that the person is a daughter of Indian mother and father. So otherwise, my lord, otherwise also case has some merit, so it may be remanded back so that she may get, otherwise her life is totally ruined.
Okay.
Maybe remanded
Proceed
back.
with it.
That is my last submission, madam.
Yes, Ms. Verma.
Lordship, since the written statement is not complete, written statement is the basis of the complete story of the petitioner lordship. So no mother's name, father's name, and the siblings' name also not reflected in the written statement. So for this lordship, I'm relying on 2017 4 GLT 346. Paragraph 25 lordship and 32, 31 and 32. Lordship, second one which I'm relying on is again on the
So
written
please give
statement.
the citation again.
Lordship, it is 2017 4 GLT 346. Rashmi Nara Begum. Paragraph 25 lordship. 31, 32.
Yes.
Second one is 2017 5 GLR 670. Jahirul Islam, JEHIRUL, Jahirul Islam lordship. Paragraphs 12 and 13.
Yes.
Paragraph 12 and 13, lordship. Then, lordship, I would like to come to oral evidence of the mother, lordship.
This, what does this say? Jairul Islam, what does it say?
It's on written statement, lordship.
Yes.
Then, lordship, on the mother's evidence, we are relying on 2023 GLT 347. Noor Begum,
How do you spell it?
paragraph
Noor, how do you spell it?
NUR BEGUM. Paragraph 6, lordship.
What does it say?
It says the statement of DW2, that is Jaharun Begum, who claimed to be the mother of the petitioner, cannot be relied upon in the absence of any documents showing her relationship either to the projected grandfather, father, or to the petitioner herself. Oral testimony of DW2 alone, sans any documentary support, cannot be treated as sufficient to prove linkage or help the cause of the petitioner. Surprisingly, the petitioner failed to produce a single voter list in her name even after the age of 50 years. We would reiterate that in a proceeding under the Foreigners Act 1946 and the Foreigners Tribunal Order 1964, the evidentiary value of oral statement without support of documentary evidence is wholly insignificant. Oral testimony alone is no proof of citizenship. Then lastly, lordship, I would like to rely on the affidavit which has been filed, lordship.
Just a moment.
Yes, lordship. 9, I think. 8. Finding okay. Just put it.
Yes,
Lordship, regarding the affidavit, Lordship, affidavit not properly verified cannot be relied upon as evidence. I'm referring to a very old judgment, Lordship, 1987, 4 SCC 481.
please give it again.
1987, 4 SCC 481, Lordship.
Name of the parties.
Shrimati Savita Ramana, SAVITHRAMMA,
Just Savita, S-A-V,
ITHRAMMA,
R-A,
MMA.
Savita Rama.
Yes, V dot. That means versus Cecilia Narohan, CECIL NARONHA. For SCC 481. 1987, 4 SCC 481. Proposition is Lordship, affidavit not properly verified cannot be relied upon as evidence.
It's not coming. 1987, 4 SCC 481.
Yes, Lordship.
No,
Then I have another one, Lordship can take that. I will also search this out,
it is
Lordship.
not also coming with the name of Savitha Rama. SAVITHARAMMA.
But that is what is the citation is showing here, Lordship. Lordship, there's another one. AIR 1970 SC 652.
AIR
1970 SC 652.
ध्यान है ना?
Affidavit
था,
without proper verification has no evidentiary value. Oh. That's too cold, है? Full idea, na? Full idea, na? That like this. AIR 1970 SC 650. Yeah.
Yes.
Nambiar, paisa. Itu আছে affidavit without proper verification. Paragraph उत्तर से success. Proof of affidavit. is the Verification.
Live on, eh? We'll take a short break and come back.
My lord, item 11 may kindly be taken on another day.
Let somebody be there. We'll pass orders when they reach the item.
All right.
Lordship, lastly, the writ of certiorari. Yes. तो पाला ना बस आया हूँ नीचे करते करते
Page 36. Dated 14/2/2017, passed by so and so in case number so and so, reference case number so and so. They were declaring the petitioner to be a petitioner, namely Asia Khatun. ASHIYA. Khatun, KHATUN. Alias Asia, ASIYA. Asia Khatun. As a foreigner oblique illegal migrant of post 25/3/1971 stream, who was entered into India from Bangladesh illegally. Next paragraph. Upon appearance pursuant to the opinion dated, notice dated, notice served on her, the petitioner submitted her written statement, inter alia, stating that there was no cause of action for the case, semicolon. The case was registered on the basis of the case was registered on the case against the petitioner is false and baseless, semicolon. Proceedings was not maintainable. The petitioner claimed that the case is not maintainable under the Foreigners Act of 1946. And the proceedings was barred under the principles of waiver, acquiescence, and estoppel. And also, as it was collusive. It stated that the name of her father was recorded in the electoral roll of 1966 and 1970 as a regular voter of number 42, Abhayapuri, within bracket SC, bracket close, LAC. And his name also appeared in the electoral rolls of 1985 in the number 34, Abhayapuri North, LAC. And that her name is recorded in the electoral roll of 1997 as a regular voter of 34 Abhayapuri North, LAC. Which the petitioner claimed not claimed, the petitioner reserved her right to file additional written statement if circumstances so arises. Next paragraph. in support of a statement, the petitioner had submitted an affidavit, evidence on affidavit reiterating the statements made in the written statement and exhibited the electoral rules of 1996 within bracket exhibit 1, electoral roll of 1966 within bracket exhibit 2, make 1970. Just say within bracket wrongly written as electoral roll of 1966 into comma blue, bracket blue, comma electoral roll of 1985 exhibit 3, electoral roll of 1997 within bracket exhibit 4, and electoral roll of 2014 within bracket exhibit 5. She had also obtained a link certificate from the office of the secretary, comma Rangapani, RANGAPANI, Gaon Panchayat, dated 26/6/2015, which was marked as exhibit 6. Full stop. She has also examined as DW2 her projected mother, namely Musammat, MUSSTT, Full Bhanu, FULBHANU, Bewa, BEWA, alias Full Jan, FULJAN, BB, comma, who had stated, comma, inter alia, comma, that she's filed the evidence on affidavit in support of the defense of his daughter. He claimed to be an Indian national by birth and has stated that her husband's name is recorded in the electoral roll of 1966 as a regular voter of number 42 Abhayapuri within bracket SC, bracket was LAC, within bracket exhibit 1, and that her name appeared in the electoral roll of 1970 of 42 Abhayapuri SC LAC within bracket exhibit 2, and that her name also appears in the electoral roll of 1985 as a regular voter of 34 Abhayapuri North LAC within bracket exhibit 3. She has also obtained an electoral photo identity card within bracket EPIC for short, bracket closed, in the name of Full Bhanu, FULBHANU, Bewa, BEWA, instead of her actual name within inverted commas, Fuljan Bewa, inverted comma closed. Where is the record? Where is the record? within bracket, exhibit one. She stated that her daughter, i.e. the petitioner, had got married with Mohammed MD Idris, IDRIS, Ali of village Tupkachar, TUPKACHAR, under PS Merer, MERERCHAR, Merer Shah, in the district of Bongaigaon. And that her daughter did not exercise her voting right with them because before attaining her age of majority, she was married. He stated that he has 6 issues born out of her marital life. And accordingly, she has stated that being her daughter, the petitioner is an Indian citizen. Full stop. The learned tribunal, upon appreciation of the readings and evidence on record, examined all the 8 the bank passbook or diary? Bank passbook. Then I 6, 7, 8. Let's just say at this juncture, it may be mentioned that if that in the that along with her evidence on affidavit, which was filed on 12/2/2016, only 6 documents referred above were exhibited, which were marked as exhibit EXT exhibit 1 to exhibit 6. So the DW2 had filed her evidence on affidavit on 28/3/2016, where she had exhibited 3 documents referred above, which were marked as exhibit 1 Exhibit 2 and Exhibit 3. First of the DW2 was examined by the tribunal on 29/4. No. It was examined. Was examined on 29/4/2016. Into can I put it 29/4/16. Okay, 29/4. 15. First one, as per the TCR, by filing of FIRISTI, FIRISTI, on 11/7/2016, two additional documents were submitted as exhibit. Two additional documents were submitted, being the PAN card of the petitioner within bracket Exhibit 7 and bank passbook within bracket Exhibit 8. So, however, the said two documents are not supported by any evidence on affidavit, and there is no order of the learned tribunal accepting these said documents. To stop, as per order dated 11/7/2016, the petitioner had filed additional documents. To stop, however, the presiding officer was on leave. So no steps was taken on that day, and the matter was fixed on 6/9/2016 for argument. To stop. The order sheet shows that the arguments were heard on 6/9/2016, and thereafter, and thereafter, the matter was fixed on 21/11/16 and 14/2/2017, when the petitioner was absent, and thereafter the opinion was rendered on 14/2/2017. From this, there is no order of accepting the said two additional documents as evidence. Stop. Nonetheless, both the documents are found to have been considered by the both the additional documents are found to be considered by the learned tribunal in the impugn opinion. Full stop. It would suffice to say that on consideration of the documentary evidence, pleadings and the evidence on affidavit, the Exhibit 6 was discarded as the issuing authority was not examined. The additional documents like PAN card and the bank passbook were discarded as those were not sufficient to establish link with the projected father. Stop. It was held that on the basis of the other exhibited documents, the petitioner has not been able to prove her link with her projected father. By discussing the evidence of DW2, it was held that the petitioner could not prove that he is the person whose name appeared in exhibit 1, 2, and 3 as Fuljan Bibi and Fuljan Nessa. The evidence of DW2 was not found reliable to determine the nationality of the petitioner because she does not know the name of her son-in-law, i.e. the husband of the petitioner. Accordingly, it was held that the petitioner had failed to discharge her burden to prove that she was born to genuine Indian parents and acquired citizenship by birth. And accordingly, the opinion was rendered in favor of the state and against the petitioner, holding her to be an illegal migrant of post 25 1971. Next paragraph. The learned counsel for the petitioner has submitted that the documents exhibited by the petitioner establishes the link of the petitioner with Asir Uddin Sheikh, Sheikh, the projected father of the petitioner, without any iota of doubt. And therefore, minor discrepancies in the name and age of the voters should not be considered as a ground to deny the petitioner of citizenship right. Full stop. It is submitted that the petitioner has produced a copy of Jamabandi relating to a land covered by Dag number 77 of Patta number 10, measuring 1 bigha, 1 katha, 11 dacha. It shows that the said land was mutated in the name of the petitioner and the petitioner, petitioner's mother, projected mother, and other siblings. Accordingly, it is submitted that in the event the court is dissatisfied with the nature of evidence led by the petitioner, or the matter be remanded, just to enable the petitioner to prove additional documents like the copy of Jamabandi, which is filed along with the writ petition. Next paragraph. The per contra, the learned standing counsel for the FP matters has submitted that the written statement does not disclose the entire facts or the family names of the family members and not even the name of the projected mother of the petitioner. So accordingly, it is submitted that the in exercise of writ of certiorari, the court would not appreciate the evidence as an appellate court, but the purpose is only to see that the opinion is not vitiated by misreading of pleadings or evidence or non-consideration of any material which is before the tribunal. In support of our submission, the learned counsel for the FT Matters has placed reliance on the following cases. Rashmi Nara Begum, RASHMINARA, Rashmi Nara Begum versus Union of India, 2017, within bracket 4, bracket GLT 346, Jahirul Islam, JEHIRUL, Islam versus Union of India, within bracket 2017, bracket 5 GLR 670, Noor Begum, NUR, BEGUM versus Union of India, 2020, within bracket 3, bracket was GLT 347, comma, Srimati, it was Savita Rama, Srimati Savita Rama versus that I can again. This will give you a transfer. Year 1988, SC 1987, comma, A, full stop K, full stop K, full stop Nambiar, NAMBIAR versus Union of India, AR 1970, SC 652, and at Central Council of Students, Ayurvedic Sciences versus Bikartan Das. Okay. Next one. Here. Examine the TCR and also consider the submissions made at the bar, as well as the cases cited at the bar. Next paragraph. On examinations of the materials available on record, it is seen that in the written statement, the petitioner has not disclosed the names of her projected father or projected mother. She has not given the names of any other family members or siblings, including this, and thus, the disclosure of the names of grandparents, parents, and siblings is not there in the written statement. Full stop. The petitioner has also not disclosed the approximate date or year of her marriage, or the name of her husband in a written statement. Full stop. In a evidence on affidavit, which was filed on 14/3/2017, the petitioner has also not disclosed the name of her grandparents, parents, or other siblings. So she has only stated that the name of her parents is recorded in the voters list of 1966, 1970, 1985, and disclosed that she is married with Muhammad Idris Ali, and the year of her marriage is left blank. And she stated that her name is recorded in the electoral roll of 1997. And 2014. Full stop. Thus, in the absence of disclosure of the names of the projected parents of the petitioner, comma, it is, the court is constrained to hold that the, that though the petitioner has exhibited the electoral roll of 1966 within bracket exhibit 1, comma 1970 within bracket exhibit 2, comma 1985 within bracket exhibit 3, comma, but none of the entries contained therein has been proved. Especially to show her link with the, with her projected parents. First of all, her name appearing in the voters list of 1997 makes it a post 25/3/1971 document. And in this case, the petitioner is required to show that either her grandparents or her parents were in the country before 1/1/1966. Full stop. It may also be stated that nowhere in the nowhere in the written statement or in the evidence on affidavit, comma, the petitioner has stated where she was born. Next paragraph. Though the petitioner has produced a projected mother as DW2, comma, but in recording a name before the learned tribunal, when she was examined on 29/4/2010, she has disclosed her name as Kul Bhanu Beva. So she cannot say when did her husband or she had cast her vote. She cannot say the name of other persons, the name of persons which appear in the voters list of 1966. Or her relation with Salimon Bibi, whose name appears in the said voters list. She has stated that the name Kudus Ali appearing in the voters list of 1966 was her son, but had died. She has disclosed her name of her son as Siddiq Ali. And she had admitted that that her daughter has not given vote earlier. And she cannot disclose she does not know the name of the, and she cannot say the name of the husband of the petitioner. the j- land record, the Jamabandi, copy of Jamabandi, which is filed by the petitioner as Annexure 6 to the writ petition. We, on a perusal of the same, we find it strange that in the SMS copy of the Jamabandi, the names of 9 legal heirs of Asiruddin is mutated pursuant to order dated 29/9/2016 passed by the circle officer in the concerned mutation case referred therein. So how in the English translation, there too, English translation thereof, comma, for reasons best known to the learned counsel for the petitioner, comma, only names of 8 legal heirs have been disclosed. Full stop. The 2 names left out is of Fuljan Deva, FULJN, Fuljan Deva, and and Somiron Nessa, SAMI Somiron Nessa, whose name appeared at serial number 10 and 7 respectively of the SMS version of the Jamabandi. Therefore, even during mutation, which was done by the order dated 29/9/2016, the existence of full Bhanu Nessa is not there in the land records. And therefore, it is difficult for the court, while exercising statutory jurisdiction, to presume that Fuljan Deva has an alias of Fuljan Bibi. Full Bhanu Beva. Sorry, Full Bhanu Beva, Fuljan Bibi, alias of Spencer. Full stop. The evidence of DW2 is not found to inspire any confidence of the court Because in paragraph 9 of her evidence on affidavit, she is disclosed having 6 children, whereas in the land records within bracket Jamabandi, there is existence of s- 8 children of the deceased Asiruddin. Next paragraph. Accordingly, comma. Oh. Okay, we'll complete the dictation in the chamber. We are dismissing it. There's a meeting I have to attend.
Well, this writ petition has been filed by the brother of the victim, well, with basically with 2 prayers at page number 15. Number 1, they pray that they immediately entrust the investigation, page number 15, immediately entrust the investigation into the unnatural death of Ratan Narjari, Ratna, to an impartial and neutral agency like CBI or High Court monitored special investigating team in and a judicial inquiry by the concerned district and session judge. That is number 1. And secondly, the arrest of army personnel, Assam police personnel, and I'm not on that. The main other prayer is directing the respondents to pay compensation. That is their main prayer. So in the petition, as regard the first prayer regarding investigation, further investigation by the independent agency, well, my respectful submission is, in the petition, we have filed the affidavit and the investigations, 2 cases were registered. Police has registered 1 case, and the wife of the victim, she has also lodged an FIR. That was also registered firstly as Runikata PS 68 of 16. Subsequently, it was registered as Kokrajhar PS 571 of 2020. The police case registered, it was Kokrajhar PS 734 of 16. And in both the cases, my lord, FR has been submitted. And the records of investigation, the statements, postmortem report, and all other documents already are placed before your lordship. My lord, those are available with the lordship. My lord,
Yes,
after my lord, from the records, my lord, two issues lordship my lord, has arisen in this matter, my lord. The number one, my lord, in my respectful submission is, my lord, whether the allegations are completely or partially true or entirely, my lord, it is wrong, because the petitioner has contended that according to the petitioner, it is a planned murder. He was murdered. We say that it was a my lord, my lord, it was in retaliation. He was killed. So their allegation is that it is a fake encounter. So lordship will see, my lord, the allegations are completely or partially true or entirely wrong, or whether the encounter is genuine or not. That is one aspect. And the second aspect, my lord, lordship will see, my lord, while deciding the matter, my lord, the honorable court will see the materials on record like complaints, postmortem report, inquest, evidence of witnesses, investigation, a report, and other inquiry reports are also there. Those lordship will see, and lordship will, my lord, examine whether the police action is in discharge of their official duty. That is one aspect. And secondly, my lord, whether the materials which are available before your lordship, those can be relied, credibility is there or not. But if the police has not acted in discharging their action duties, my lord, or the materials are, my lord, so, my lord, the materials suggest that they have not acted in discharge of their duties, and it creates doubt, then of course, my lord, the first prayer of investigation that lordship will consider. My lord, kindly take up the affidavit of the respondent number 6, my lord. He is the SP. According to us, what has happened on that day, we have narrated in this affidavit.
we are sending this records to you.
My lord. Yes, lord. Yes, lord. So, lord.
The army was requested on a verbal advice to accompany them. That was there.
My lord.
But we tried to find out, we don't find any corresponding GD entry for the movement of the police along with the armed forces to go to the site. That perhaps we have missed out.
My lord, I'll check up, my lord. Okay. Lord, here a
Because
discrepancy.
we are saying for it for two reasons. Number one,
they said that in the affidavit of the Union of India, they said that they were only asked to go to them and therefore they went up to a particular point in the eastern part of the river and then they stopped there. And they heard